Welcome to the Trusted Podcast with your host, Blake Johnson. In each episode, Blake interviews professionals in different areas of life that you need a trusted source of information, including trust and estate planning. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, trustedepa.com. Now, here's the host of Trusted Podcast, Blake Johnson.
Well, hello and welcome to the Trusted Podcast. Great to be back with you today. As you know, I'm the owner of Trusted Estate Planning Attorney. So today we're going to focus on something a little more focused on estate planning and actually what happens when you don't plan. And so I've got Holly AlDabbagh with us today, and she's one of the associates at Trusted, and she's our probate, heads our probate department. So Holly, thank you for being with us today.
Hello, thank you for having me.
Well, why don't you start off telling us a little bit about yourself, how you kind of got into estate planning and specifically probate stuff.
Yeah, so I graduated from the University of Nevada, Las Vegas in 2016 with an undergrad bachelor's in political science and a minor in communication studies. And then I went to law school. I kind of always knew I wanted to go to law school. I worked for various law firms throughout undergrad in like a legal assistant role. I was lucky enough that I worked for a really large firm, so I got to see various types of law, including estate planning. And then when I was in law school, one of my externships, which is where you basically get credit for school instead of getting paid, I worked for the Southern Nevada Senior Law Program. And that is a really cool program that I think it's Clark County provides for senior citizens. Anybody over the age of 65 in Clark County can come get free estate planning done for them. It's basic estate planning that they provided, but I learned a lot. And I saw, through doing that, I saw the other side of what happens when you don't get an estate set up. We had multiple people come to us at the senior law program saying, hey, my parents passed away. They don't have a will. Can you help us? And we'd have to turn them away and say, nope, it's too late. You have to go through probate. So that's kind of how I got interested in estate planning and how I learned about the benefits of it and what happens when you don't plan accordingly.
Okay. Well, what do you like to do outside of work? Something interesting most people don't know about Holly.
I love.
Wouldn't assume.
Yeah, I love action adventure movies. I don't like reality TV at all. I can't stand any of the Housewives or any of that. So I like a good thriller action movie. I love all of the Marvel movies. So my husband and I love watching those. But I'm obsessed with my dogs. We have 2 dogs that are my whole world right now since we don't have kids yet. And so I love going on walks and hiking and swimming and being outside as much as possible when it's not 120 degrees here.
Yes, it's hard to get out in the summer.
Mm-hmm.
Okay. Well, what are some areas or maybe even some horror stories of, maybe let's back up. Give us a basic overview of probate.
Mm-hmm.
Why someone would have to go through the probate process? What is probate court? And then, some stories that kind of go along with people who didn't plan accordingly.
Yeah, absolutely. So to go through the basics of kind of what probate is and why it's necessary, in Nevada, if you own more than $25,000 worth of stuff, then your estate has to go through probate when you pass away if you did not have all of that stuff in a trust. And all of that stuff is referred to as an estate. So if your estate is larger than $25,000 when you pass away, it has to go through probate. It's by law. So any banks, title companies, they will not give you as an heir access to any of those assets unless you have an order from the probate court. So it's just a fact of life that you have to go through it if you don't have your assets in a trust. And the way that it works is when somebody passes away, they would come to our office. We would have an initial consult with them. We would draft up the initial paperwork. We would file the case with the courts. You're not even going to get the initial hearing, which is required in most cases, until a month and a half or 2 months out. At that initial hearing date, whichever heir has signed up to kind of power through this process with us, they will be appointed as the personal representative for the estate. And then there's the kicker. For estates that are worth between $100,000 and $300,000, you have to have a 60-day, what's called notice to creditor period. For estates worth more than $300,000, you have to have a 90-day notice to creditor period. It's mandatory by law, and the estate basically just sits there frozen for those 60 or 90 days, giving creditors time to come make a claim like, hey, the deceased owed $25,000 on his Chase credit card, and he owed this much money for a medical bill. So anyways, the estate's just frozen for those 60 or 90 days while you wait. And then at the end of that period, you have to submit the final paperwork and final order to the judge, who right now is taking 5 weeks to sign orders. So at the end of those 90 days, you still have to wait an additional 5 weeks. And so during that time, everything is essentially frozen. So that's kind of the process. And then in terms of the horror stories, just the timeline alone is a horror story in and of itself. You either have to decide as the heirs if you're going to pay the mortgage on the house during that time from your own funds, or then the house starts facing foreclosure. You have to take care of the utilities and things if you don't want them falling into disarray without access to the deceased's assets. So that's just the basic horribleness of it all. But I've had some other really bad stories where things get held up. Either Medicaid has some sort of lien on the property, which creates a whole host of issues and can stretch out cases months longer than they were ever intended to be. Sometimes when you're going through probate, siblings start bickering. It's a very stressful process. We had a case where Blake and I where we were going to do a probate for this woman. Her mother had passed away. She had one biological sister and one half sister as well. At the beginning, when we took on the case, she said they were all getting along and everything was great and fine. So we file the case. We get our hearing date. It's about 2 months out. The day before the hearing, her sister, who lived in Arizona, hired an attorney and filed an objection, which right then just throws a giant wrench into everything. She was hurt that she wasn't included enough. And so who knows, grief, whatever, but it became a massive thing where now you have to have additional hearings. Motions were filed, objections were filed. You have to get into discovery. It turned into what should have been an open and shut general administration. It's still ongoing a year and a half later. So that's just one off the top of my head. That was one of the worst that I've seen.
Yeah, it's amazing. I say this all the time when I speak at places. People think, well, that won't happen to my family. My family gets along. One of the biggest myths I have is I always say, it will happen to your family. You're not special, unfortunately.
Right. Yep. Exactly.
So yeah, that's it. A couple other things I want to clarify, just so that we're clear for the listeners. One is if you have beneficiaries on your accounts, those do not have to go through probate. Right. Whether that's a bank account, life insurance, 401k, that kind of stuff. So that is excluded. The problem is if someone dies that was listed as the beneficiary, then we're back in probate. And then real estate, that's the main reason we see probate happen is somebody had the house, they forgot to put, they didn't put, there is a deed upon death where you put a beneficiary, but we don't recommend those. And so, there's no joint tenant. So when they pass away, kids think, I can just go sell the house. That's not the case. So that's where
exactly. Another piece of information on that I have run into recently for deeds for houses, I have two different sets of clients right now, two wives whose husbands have passed away, and they were only listed on the deed as husband and wife. It didn't say as joint tenants. And if you're missing those two words, joint tenants, on your deed of your house, you're stuck going through probate for your spouse's half of the house. So it's just very, very important for spouses when they're buying property to make sure those words joint tenant are included on your deed. Otherwise, you're stuck going through probate for their entire half of the house.
Yeah, and in some states, it's required even more. It has to say joint tenants with right of survivorship. They get even more clear. So, and unfortunately, when you buy a house, there's no one there giving you that advice. The title company says, how do you want to take title? And you don't know. You're not a specialist, but that is key. Joint tenants with right of survivorship, if you're having that. And then afterwards, ideally, you put it in a trust. Would be
right. Yeah.
So what are the three biggest myths? Maybe not three, just one to three myths and misunderstandings you see happen either leading into probate or while in probate court?
So leading into probate, I have another example of a client situation. So her uncle lived here in Nevada. He essentially lived paycheck to paycheck, had nothing in his checking account, no life insurance policies. His retirement ended with him, and Social Security ended with him. But he did own his house here outright. And it was in a shadier part of town, a smaller house. Maybe he didn't know how much it would be worth, but it was worth about $300,000. And he owned it outright. And I'm sure he bought it for way less and maybe didn't know it was worth this much. But a myth I see is somebody like that, no spouse, he didn't have any kids of his own. He's thinking, why on earth would I need a trust? Why should I I don't have anything to put in a trust. Why do I need it? It's not important. Well, now his three nieces and nephews are stuck going through probate with us. They're having to worry about the utilities for the house. The house, they don't live here, so they're worried about getting vandalized while it has to sit there, and they go through this whole probate process because I would love a third of $300,000, and so now, but they're having to spend money on court fees, our attorney's fees, the time, all of these extra things that they would not have to go through, wait for, or spend money on if he had put his house into a trust. It would have been a simple process. So even if there's people out there that think, I don't have any assets, or I don't have any family members, or I don't have anybody to leave this to, I'm sure you could think of somebody, and that somebody would appreciate not having to go through probate. So that's one of the biggest myths I see is people thinking I don't have enough, therefore I don't need a trust. What
about having a will? That's when I hear a lot. Well, I have a will, I'm good. Right?
Another huge misconception. So people think a will help them avoid probate. It absolutely will not. A will always goes to probate. So a will is essentially just a letter to the probate court judge saying, hey, this is who I want to get all of my stuff. But you still have to go through the entire probate process. It doesn't speed anything up. It doesn't make it, you avoid it in any way at all. So yeah, okay. Will is definitely, that's a myth. One other myth I think is that people think it's easy to sell real estate during the probate process. It is not. I have lots of clients that think, oh, it's the market's, in need of houses, and the house is just going to sell like that. And no, it's very difficult to sell real estate during probate. You usually have to have a hearing. Your buyer could be overbid. The house essentially goes to auction. It can create all sorts of headaches. It can end up dragging out the probate process longer than if they would have just waited to sell the house out of probate. So a lot of times people think, oh, yeah, I have to go through probate, but I can just sell the house as soon as I'm appointed as the administrator. It takes a lot more time and effort than that. It still doesn't make it easy.
Yeah, those are great examples there. All right. Any upcoming changes in your industry that you're aware of? And if not, what areas do you think need to be improved, or how would you change the probate court process?
I wish so much that we could have an additional probate commissioner. So a lot of people don't realize that in Clark County, there is one man, one probate commissioner that oversees all of these probate cases. And probate hearings are held every Friday. So every Friday morning is the probate calendar for Clark County. And there are usually like 140 to 180 cases per week. So one man is sifting through all of that. I would love it if we could have another commissioner appointed. There's definitely a need for that, because one of the main hiccups we're seeing lately is, okay, yeah, you have to wait so long to get a hearing, and then you have to wait the notice to creditor period. Those are by law. I understand that those things have to happen. But now, after a hearing, when I submit an order, you'd think the order that the judge just ordered at the hearing should be signed within a day or two. It's taking 5 weeks to get orders signed. So it's just making it way longer than it even needs to be. So I really wish that was smoother.
Well, I've got good news. I heard yesterday they actually opened a position. So
Yes.
hopefully, I mean, I've been saying that for 10 years. I think it's actually been said by every attorney in Clark County for 10 years. So yeah, hopefully.
Hopefully.
And you feel bad for that commissioner, because
I do.
They have 3 or 4 clerks, and they're doing that much work. They have no way to catch a break. So
Right. I feel bad for him too.
That would help expedite the process. But even then, like as you said, most of the waiting periods are by law. And
right.
So,
there's only so much you can do.
There's only so much you can do. It's going to take a while.
And then the other thing is, I wish people could understand the value of having a trust. It seems like a lot of money up front, even though it's not anything crazy, but it seems like, oh, why do it? Well, do you care about your kids? Do you want them stuck going through this process? You buy life insurance, you have car insurance, you have homeowners insurance. This is essentially insurance so that your kids, their lives are much easier when you pass away. So I just wish people understood the importance of that, and then we would have less probate cases. So that could also help.
Which, for the listeners, if you don't know, that means Holly's very unselfish, because she makes far more on a probate case than she does on a trust package.
Yeah.
And that's why you don't hear very often about trust. Most people think, especially the further east you go, oh, trusts are for the ultra rich. They're the ones who need that stuff.
Yeah.
But the reality is everybody needs it.
Yep.
The reason that other attorneys don't bring it up is because that's their retirement plan. I'm going to do all these wills for people, and then they start dying when 20, 30 years when I'm getting ready to retire, and I get to do all those probates, and I'm going to collect winning checks. And that's not the way that we operate. And the nice thing is Nevada in general is very pro trusts.
Yes.
But they tend to penalize you if you don't have a trust.
Yep. Exactly.
I think Nevada is actually the lowest probate level in the country.
It's very low. Yeah.
Yeah, 25,000. Utah's 100,000. California's 150.
Yep.
So very, very different thresholds there.
Yep. Exactly.
Let's say someone gets a case, their parents, their aunt, their uncle, whatever, didn't plan. They need probate.
Mm-hmm.
What are the things they should gather or do prior to coming to see a probate attorney?
We like to see a death certificate, but especially in Nevada, sometimes that can take a while. So it's not totally necessary. You could have an initial consultation with or without the death certificate. Obviously, eventually it will be needed. But what we like to see, what we need to know is how much their estate was worth. So if you can kind of get an idea of, did they own their home outright, or do they have a mortgage? Do you know about how much equity they had in their house? Do you know about how much they had in their bank accounts? Do they own a lot of vehicles, boats? Because the way that probate works in Nevada is there's 3 different tiers. So if their estate was worth less than $100,000, we can do what's called a set aside. If it was between $100,000 and $300,000, we do a summary administration. If it's anything over 300, we have to do a general administration. So it's nice as the attorney if the heirs are able to kind of assess where they think that level is. If not, that's okay. We have ways of helping clients find that out as the process goes along. It requires a couple additional steps, but it is doable. So if you have bank statements, if you have mortgage statements, if you can go to their house, check their mail, if they still received stuff through the mail, We'd love to see that. Obviously, if they had a will, we would need that to go through probate as well. Death certificate, if they have it. Those are the main things that I like to see in an initial consultation. We also they need to be prepared if the beneficiary has siblings. We need addresses, phone numbers, and email addresses for every single heir. So I just got a new probate client this morning. He has 6 siblings. So there's 7 of them. So I had him email me a detailed list with each sibling's name, phone number, email, and address, because we may need that for the probate process.
Yeah. You have to notice all the heirs there. Mm-hmm. More information you can get, the better. The other thing I'd add to that is be upfront. We've had issues where people come in, thinking of a case particular where they came in and said, yeah, it's just me and my sister. Mm-hmm. And then we find out, oh, no, wait, we actually had 2 half siblings in California. Yep. Okay, well, that changes everything of how we approach this.
Yeah.
So be upfront. It'll save you in the long run. Just, give that information. It's not that we're judging you or anything. We just have to have that information to advise you correctly to do the right thing.
Yeah, exactly.
So speaking of advice, what is the best advice that you've ever been given?
In regards to this, or just in life?
In life.
Best advice I've ever been given. Well, my mom gave me some funny advice that I've never forgotten when I was probably maybe 12, 13 at the time. She was like, you're going to make mistakes and you're gonna tell us lies as your parents sometimes. But she was like, don't do anything that's going to really damage your life. She was like, sneak into an R-rated movie before you're, 15 or whatever, but don't steal a car. Don't do Grand Theft Auto, right? And that's always stuck with me of, life is funny, but it's important to just stay on the right track. It's always better to be upfront, tell the truth, do the right thing. And so I just loved that as a kid. I thought it was funny, but good advice.
Yeah, it's funny. We know you're going to get in trouble, so that's fine. Just when you get in trouble, do the things that aren't going to permanently
ruin your life. Exactly. It was funny. So it's always stuck with me.
Okay. Well, any final thoughts or advice you'd give to the listeners about the probate process or anything regarding that we talked about today?
I would just say that probate is no fun, but it is mandatory. So if you are stuck going through it, our firm is excellent. And I really take time to connect with my clients and get them through it as smoothly as possible. So it is doable. Sometimes people think there's no light at the end of the tunnel when they're going through a probate case, but we do get them through it. Sometimes it takes 8 or 9 months, but at the end, you do get access to the assets. So there are people to help you if you're stuck in that situation. And then the other piece of advice would be set up a trust. Get a trust, get it set up, no matter how much money you have.
Okay, sounds good. Well, Holly, appreciate you being on the show with us today, giving us your insight into the probate world. And hopefully, we've deterred a few people from just letting it go. I've heard multiple times, I'm dead, so what does it matter? Well,
right.
It doesn't. There are people who are affected.
Yes.
And so, you got to think about, more than yourself in that situation.
Exactly. Yeah.
But with that, we'll call it an episode. Thank you, everyone, for listening. And we'll catch you next time on the Trusted Podcast.
Thank you.
You've been listening in to the Trusted Podcast with your host, Blake Johnson. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, trustedepa.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others. Please subscribe to make sure you are notified each time a new episode is released each week.